I want to show you guys how government just you in little ways over and over again. Because, well, that's what they do. Grifty says, what is alleged total weight versus April's versus yours? Well, it's tough. The alleged total weight was 26.67, I think. But that includes packaging. And the weight that is alleged to belong to April, I believe, is a 2.2 gram amount, which would assume include packaging as well. But that's really kind of unclear. Nick Rye says, has it been established who April is in relation to you? Employee, friend, lover, wife's lover, something else? Ooh, has it been established? I don't think so. Has it been established? I don't know. What do you guys think? That's probably a mistake. You guys don't answer that. What do you think? I don't know, man. It depends on what your definition of established is. Like, and I don't mean that in a shitty Bill Clinton way. I mean that in a way of like, who do you need it to be established for? Because we're not at trial. So, okay, so here we go, guys. Let's watch this. This is Judge Fisher. Never mind.
487 State versus April Imholt. Note the appearance of Thomas.
Why did homeboy breathe like that? What was going on there? He went, it's like, is he okay?
Gallagher, attorney with and on behalf of the defendant, April Imholt. Kristen Pierce, assistant county attorney, appears on behalf of the state. This is
that's an allegation. You can't prove that's my studio.
Of possession of controlled substance, a felony violation of Minnesota statute section 152.025, subdivision 2, paragraph 1, and subdivision 4, paragraph B. Maximum penalty 5 years imprisonment, a $10,000 fine, or both. Ms. Imholt, you have the right to remain silent and not submit to police interrogation. Anything you say may be used against you in this or
It's kind of funny that she would Mirandize April during this hearing and say she has the right to remain silent. Because like the officers did that and then they just ignored it. So that was cool. Good job. Good job on that one.
Any subsequent proceeding. You have the right to counsel in all proceedings, including police lineups and interrogations. You have the right to be represented by an attorney of your own choosing.
April is very blurry in this. She looks like that Scanner Darkly movie with, I think it was with Keanu Reeves. They had that weird animation style.
You're on
expense. Oh, the guy in the bottom left is a guy named Win by 2. I don't know.
Indigence, then attorney will be appointed at public expense. You have the right to communicate with defense counsel, and a continuance will be granted if necessary to permit this. You have the right to a trial before the court or a jury. Mr. Gallagher has submitted a certificate of representation. Mr. Gallagher, you've also submitted a motion to dismiss, and it's your motion.
It's my
Your Honor,
motion.
When I looked at the complaint, I'm asking the court to dismiss the complaint today based on Rule 17.06 subdivision 2.
Okay, so I'm kind of ignoring this first part, like I'm playing it for posterity, but we just went through his motion. So we know what he's doing. What I'm interested in talking with you guys about is what Kristen Pierce, county attorney, has to say in response to him. And also, you know, one of my just general complaints for the court where prosecutors get to do lawyering on easy mode and they have no rules or standards that they have to follow. It's pretty amazing.
Paren 2, Paren D, and subdivision 3. And as outlined in that rule and in the comment to that rule, if the facts alleged in the complaint do not constitute an offense, then the complaint should be dismissed. And that can be raised at any point in the proceedings, including today. The complaint, the probable cause section, I believe, is about 2.5 pages long. It mentions the defendant's name. There, I believe I put it in my motion, but in writing, but it's 5 times her name is mentioned. The first time it says she was located in the home. The second time it says she was located in the master bedroom. Third time it says 2 credit cards listed to the defendant were found. And then it says the fourth time it mentions her name. It says her purse was located in a hallway between the master bedroom leading to the attached bathroom, and that a co-defendant indicated, and the
Her background does not look familiar, you liars. What are you talking about? I'm just kidding. Obviously, she was sitting right here.
homeowner indicated that the defendant was at the home visiting at the time of the search warrant execution. Mere presence is not enough to support a possession charge. There's no allegation that she possessed any drugs. And so we're asking that the court dismiss the charge.
Ms. Pierce.
Your Honor, Ms. Imholt was found in the room where the drugs were found. She's only being charged with the drugs that were found immediately on top of her credit cards, which were active and not expired. One was a bank card, and
Okay, so here's where we get into the meat of this, and this is where it starts to like matter what's being said a little bit more. I mean, the other stuff mattered, but we went through it in the paper motion, so we didn't really need to hear Mr. Gallagher's words, as eloquent and wonderful as they were. We've just now gotten that she's only being charged with the amount that was quote directly on top of the cards. And this fact becomes pretty interesting in just a second, because you're about to hear a lie from Miss Pierce.
and her purse was found in the master bedroom suite.
Okay, so real quick, sorry, I just have to do this again. If you're next to drugs, but they're not your drugs, and you don't know that they're there, you don't own drugs. Okay, so this is a kind of a, like, possession is not just you're around something. So if you take the allegations of the search warrant execution, the complaint is true, and you say that there's this controlled substance, and April's in this room, then they go, well, you still have to prove that there's possession. So you can't just like be like, well, they're there. And that's what the complaint was. The complaint was, this was there, April was here, therefore, but except they left out the therefore. So we're now finally getting it. But they're saying that this vial that tested positive for cocaine was sitting on top of a couple credit cards, on top of a nightstand, and therefore April is in possession of that. That's their claim. Now, this gets legally wonky in a bit.
Which between the master bedroom and the bathroom. And she was in the room when law enforcement executed the search warrant, and the drugs were out in the open on top of her immediate possessions with the rest of the
That is not accurate to the police report. And that's an interesting thing there. That is the first time and only time that I'm aware that the state has claimed that the drugs were out in the open. Miss Pierce has misrepresented a material fact right to the court. At least if we're to believe the complaint, because the complaint, let me just go back to what it says. The complaint says following items were located in the master bedroom near the nightstand, black vial with white substance inside that field tested positive for cocaine and weighed 2.2 grams. That's not out in the open. And the reason that matters is because there's an actual statute in Minnesota that says if drugs are out in the open, then anyone in the room is presumptively in possession of them. It avoids this problem that you can kind of imagine in a hypothetical scenario where there's like a mountain of meth, right, on a table, and there's like 10 people all standing around, and they all go, it's that one's like, it's that someone else's meth, right? Like everybody's pointing at everybody else's meth. They do the Spider-Man thing. His meth, his meth, his. Minnesota created a law that says if drugs are out in the open, then everyone who's in the presence of them is presumptively in possession of it at the time for the purposes of the statute. And so this is interesting because without that fact, it's possible this complaint is deficient on its face, and it's possible that this complaint is deficient as it still stands, because they're not out in the open. So there's nothing here then establishing possession. They could maybe try again, maybe they have different facts. I don't know. But from what they've put in the complaint, there's nothing. First of all, they don't even allege the possession, but there's nothing actually establishing the possession by April. The only thing that would be establishing it would be this out in the open sort of comment, puts it presumptively under the possession because of that special statute. And this is one of those things where this is a lie. Like this is an officer of the court. This is the prosecutor in this case. And she's representing to the court that this was different than what is in the actual complaint. You know, that's fine though, right? Like it's just a felony charge. It's just the government telling people that you did something illegal. What's it matter if they just have the facts incorrect, right? Like what's that matter? But they do it. And it's not really a polite or useful way to bring this up. That's what makes it difficult as well. I mean, I guess Mr. Gallagher could have objected here. Does he win much from the objection? I'm not quite sure. But what he does now have, in my opinion, is actually this nice piece of ammunition. Because I don't think an objection here actually wins him the case all around. But having the prosecutor now misrepresented the facts on the record, that's an arrow in the quiver.
Contents of her purse also in that room. While mere presence is not enough, that does show.
And actually, there was a subsequent one. If you go through that complaint again, that statement of probable cause, the contents of the purse are not in that room. The contents of the purse are in the purse, which is kind of a weird sort of misrepresentation that is done by the government actor here. And I'm just not quite sure why they would go ahead and do that. But hey, you know,
that she was in the room and creates a joint possession that she was using, or at least with one of the homeowners in that bedroom where the drugs were out in the open, on top of literally on top of her property, of her bank cards.
There's that in the open thing, not in the criminal complaint at all.
Huh?
Why is he confused?
For today's purposes, I'm denying the motion without prejudice.
Denied!
I think the motion is not as simple as the defense filing would make it seem, considering Ms. Pierce's take on the evidence, and that the motion to dismiss would be more appropriate for a Rule 11 motion where the parties could dive in a little deeper to present the court with the full flavor of the evidence. And so for today's purposes, it's denied. And Mr. Gallagher, would you like to combine Rule 5 and Rule 8 today?
So there you go. Read out the criminal complaint. Like I did.
Yes.
I did just a
All
second
right,
ago.
are you
weirdo.
waiving reading of the complaint, deferring entry of a plea, and demanding an omnibus hearing?
Lock her up!
Yes.
And are you wanting the contested omnibus hearing right away?
Or
Or do you want to be on the uncontested block first?
I think we'd
Another win for the
rather be on the uncontested block because every now and then discovery issues pop up.
Yep, and that's fine. The purpose in our county for the uncontested omnibus is for the defendant to either demand or waive the contested omnibus. So it does buy you a little time, and then the case is not assigned yet. We'll assign it once you demand or waive omnibus.
I can't get over she's in Nick's studio. Oh, poor Abe. She's gonna cry.
AJME CD says, wait, the prosecutor said she was a user because she was in a room where there were suspected drugs. That doesn't make sense. That's, you know, some people would say that doesn't make sense. Stephen Crater says, did you see that a Candy, Ohio County deputy was charged with DWI after rolling a squad car multiple times on August 14th? I did. He was not, as far as I'm aware, he was not one of the deputies that was involved in my situation. I wish him a speedy recovery and a swift prosecution for driving under the influence. Seems kind of like he shouldn't do that, I would think. There's not much left. They're going to go through the release conditions.
September 17th at 2:30.
That's out of 14 days.
Oh, sorry.
Would be the 11th at 2:45.
We would waive
September
any
11th.
time.
Oh,
2
limits,
weeks.
by the way.
gosh, I'm thinking, I'm totally sorry. My fault.
Yeah, you're being
Okay,
watched.
time is waived. So
Judge.
the 17th, a lot of our prosecutors are gone.
Okay, I'm not going to sit here and do this actually because it's getting annoying. Look, long story short, they schedule it out and then it goes into the rest of it's uninteresting to me. I'll just summarize. They go into the terms of release. Obviously, this was by Zoom, and clearly, April was attending from the Candy, Ohio County Jail, as you can tell by the blurred background. But because of that, the release conditions were set by the judge as a $20,000 unconditional release bail, or release conditions, which would be released on your own recognizance, stay in contact with your attorney, no leaving the state without permission, remain law abiding, and then importantly, no ownership or use of mood altering substances, including alcohol, which is a standard. If you have a case involving any substance from DUI to possession to sales, they will have a restriction on use of any controlled substances or use of any mood altering substances. And it basically always includes alcohol. Personally, I think that's a little bit, I think that's a really shitty thing that they do, because if someone's charged with, use of, I don't know, fentanyl or whatever, their use of alcohol isn't related to the fentanyl use. So I don't see any nexus to do that, but they just blanket restrict everything. So that would be the conditions. So the way that bail works in Minnesota is you can either post the cash amount of $20,000, or you can get a bond. The bond would cost $2,000, and then a bonding agent would put up the bail money. If you post the full cash value upon your completion of your case, as long as you make it to all your hearings, you actually get that money back in full. If you post a bond, you're out the money that you spent on the bond. Trade-off for having to pay 10% less. But what I want you guys to do, just as an exercise, is go to your kitchen and get the sugar out, right? And get a teaspoon like that you would eat cereal with, and put about fill up a quarter to a half of that with sugar. And then say that amount of a substance amounts to $20,000 of bail. Remember that we haven't, people made fun of me for this because I just asserted, knowing that it wasn't going to change, but asserted that bail in my case, I believe, is excessive. $50,000 bail seems excessive for a first-time possession charge, but hey, that's my opinion, man, or whatever. April's is a 5th-degree possession charge, and I think a $20,000 bail is a little bit much for me. It's kind of wild to think that they're well, that seems reasonable. if you don't want to live under the government's restrictions of your liberty, you just pay $20,000. We'll give it back. If you're found guilty and you have a fine or any restitution, we'll take it out of that $20,000. And they know they're going to get it. So it's kind of like they might find a way to spend it or award it, that might happen. But it's, to me, I just have a problem with the way we do bail on this stuff. Of course, it's only the 2,000 if you do a bond or whatever. In our case, it's only the 5,000 to do a bond. But it's like, I don't know a lot of people with that kind of money lying around. And plus you're paying lawyers and, you have other issues going on that you have to deal with. And it's, it piles up like crazy. And I really do wonder, like the 8th Amendment, it says no unreasonable bail shall be set. And it's like, well, what actually is reasonable bail? We accept bail, but what is, like, conceptually, where is it? Allegan News says you could save April and wife and admit all of it was yours. You could save all of us and admit all of it was yours. What do you, damn, why don't you try that one?